All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Our first case today is number 20-1479, Furst versus Rebholz. Counsel, whenever you're ready.
Thank you, Your Honor. Jason Lessinger on behalf of the petitioner, Bill Furst, Sarasota County property appraiser. May it please the court, the material facts in this case demonstrate that the property at issue, a single-family residence, was designed, built, and utilized as a boarding house. It had individual dwelling units upstairs. The landlord of that property signed leases with his tenants, giving them exclusive possession of portions of that structure, including one for over 15 years. That is unquestionably a commercial purpose as it is defined in the Florida statutes. As we know, under 196.015, determination of a permanent residence is a factual determination initially made by the property appraiser, with any disputes in that regard being resolved by a trial court judge.
Counsel, I'm sorry to interrupt you. So in this case, it seems like if there is an ability to segregate a home, this is obviously a strong case for that. But you mentioned a bunch of different variables, that there was a written lease, that it was for a long period of time, et cetera, et cetera. In this case, there's a specific area of the home that could easily be segregated from the rest. You mentioned that it was designed for that purpose. I'm trying to understand textually what we should be looking to for the appropriate test. Because obviously one concern that this case raises is, what about these gray areas where it's not as stark, the sort of distinctness of the part of the home is not as stark, the financial relationship is not as obvious, the pre-planning might not be there. So what should we be looking to for the actual standard?
Candidly, you need to look at the facts of a particular case. That's what the property appraiser does. How is this property being used? Factually, is it a commercial purpose? Now, I can certainly walk you through some examples of where it gets grayer and where I would believe that those are not necessarily a commercial purpose, if that's your question. Well,
but where is the commercial, and are you linking that to the definition section, or where, because it seems like the controlling statute that sort of lays out the basic exemption in that part of the statute, it doesn't talk about commercial purpose, right? It talks about residence, and there's a possibility that implies that it's not being used for a commercial purpose. Then you have the definition of the phrase, used and owned and used as homestead property, where it does have the commercial thing, but that phrase itself only appears in parts of the chapter that don't really directly apply here. So I'm just trying to understand where we look for the test that governs this case.
Well, first you would look to the actual provision of the Constitution, which confirms that you only get the homestead exemption on the portion of property that is your permanent residence. Okay? So if you're not using that portion of any property, whether it's a multi-use property or a single-family residence, if you're not using that portion of the property as your homestead, well, then it doesn't qualify for the homestead exemption. You're not using it as your permanent residence, excuse me, I misspoke. It doesn't qualify as your homestead. Now, for example, there's been a number of examples thrown out. Judge Sleet, when we were arguing this before the second DCA, commented that if his daughter came home from college and stayed there for the summer and chipped in for rent, would that be a commercial purpose? Well, absolutely not. under those basic facts, when you're dealing with the family home and you're dealing with a relative coming in and maybe chipping in for expenses, that probably doesn't qualify.
What if it's a short-term rental, not a relative, just for this 3 months?
Again, let's assume for a moment that my partner, Mr. Magnello, falls on hard times and all of a sudden needs a place to live. Hey, can I come stay at your place? Can I crash on your couch for a few months? I'll chip in a little bit. That's not a commercial purpose.
What if it's the whole house, like, you know, the short-term rental market, and you do your whole house for 3 months?
You do your whole house for 3 months.
Right.
Well, that would, you're then renting all of your unit under 196.061 for more than 30
You're renting
days.
the whole house for 3 months in the short-term rental market while you go somewhere else for the summer.
For 1 year or 2 years in a row?
Let's say, take it the first year.
The first year under 196.061, it would not be a disqualified. You would not have abandoned your homestead under that statute in 1 year. If you do it in two consecutive years, well, then you do. But that would be an abandonment of the homestead because you've rented out the entire property. No one's contending that Mr. Rebholz abandoned his homestead. He didn't rent out his entire property. He still got his homestead. He got the full exemption.
It seems to me that we have a choice. We can go down this road of we know it when we see it jurisprudence, and just sort of, as you say, focus on the facts, which seems to be shirking a little bit our obligation to say what the law is, and instead to sort of say the law is what we will say it is on a case-by-case basis, versus, I think, a thread, sort of acknowledging a thread that runs through all of these fact patterns and indeed is part of Karianakis, and that is, it seems like what you're really focusing on is a right to exclude. You're saying that if, because of the financial arrangement between these two parties, one of the things that the renter has purchased is the right to exclude the title owner from the space, then they've bought a homestead out from underneath that person. Then that person is not using that space as a private residence. Am I right that that is really what you're arguing, that it all boils down to a right to exclude?
That is a critical fact in this case, most certainly. And again, it goes back to the notion that you've got to examine the facts of any particular case. So in this case, that is a critical factor. Yes, that is a factor that demonstrates that that portion of the property is not being used as his homestead.
Can you think of a time when a property owner can claim a homestead over a residence that they have contracted away the right to inhabit? That is, if they can be lawfully excluded from the premises, can they, under any circumstances, claim it as their homestead?
Again, if it's being used for a commercial, non-exempt purpose, then
I'm trying to draw a line so that we don't have to do well, we just don't know. It depends on the facts of the case, which would seem like a very frustrating place for us to land.
right, but these statutes are not limited to an exclusive possession analysis. It's any commercial purpose. And if you've read the record, you'll hear the same example that the 6 judges that have previously considered this case have heard. Judge Bonner, when she ruled on the motion to dismiss, was very concerned about a tax lien being applied for someone who simply operates a home business.
The statutes use a 6-month period of time, right?
As to a rental. That's the only analysis or guidance that the statute provides is guidance for this particular case.
So in my hypo about the 3 months renting the whole house, that's less than 3 months is less than 6 months. Should that not be presumed residential, not commercial?
It could be, but again, you have to look at the entirety of the facts.
They phrased the statute not in a bright line rule, but it just gave a presumption. That's
right. But going back to this notion that it goes beyond exclusive possession and going back to the home-based business, you can only determine that based on an analysis of the facts. For example, if I'm running a Mary Kay operation out of my house, but I don't take it very seriously, and I sell a few pieces of makeup, and I've got a couple of boxes in my spare bedroom, and maybe even a computer in there that I do some of my business stuff on, but when my brother comes and stays at my house, he still sleeps in there. Or when my kids play hide and go seek, they still go in there. However, if my business then grows, and I go buy a bigger house, and I set aside 2 rooms in that house, one is my office, one is my storage unit, and all my stuff is stored in there, and my kids aren't allowed in there, It's no longer being used as a home. Oh, by the way, I depreciate that on my taxes. Or better yet, I form a corporation and then lease those spaces to the business. That's no longer a homestead use.
There's a problem is where do you draw the line? I mean, you also have, we come up with a million different hypothetical situations. That you have the person who basically bakes cookies and sells them to stores. I mean, out of their own kitchen. Do we does that basically become non-exempt property? That portion of the kitchen? Do we just do the oven portion of the kitchen, that portion? I mean, where do we draw the line on these things?
It's a very challenging line to draw, but it appears that the bench is struggling with the notion that ultimately comes to where the rubber hits the road in this case. Can a single-family residence, in and of itself, be divided for homestead purposes?
Well, it would seem to me that in your case, there's no dispute that the owner of the home alienated away from himself the right to occupy the locked rooms that he was renting out, right?
Yes.
All right, so why isn't that the end of the case? Why doesn't that end the analysis under the statute?
It would end the analysis in this case. It doesn't end the analysis in all of the cases, and the justices are looking for a rule and how to interpret this broadly.
So
Go ahead.
And the statute that I've been referring to is a 6-month. The lease to this particular tenant was more than 6 months. Why don't we just apply the statute there?
Because it's only a presumption.
Well, I mean,
if you rent it for more than 6 months, it's presumed commercial.
Well,
now, I would
apply
suggest
the presumption and then look to the other facts to determine it was a long-term conveyance of entrance through a lease. Therefore, it's you allocate the cost, right?
Essentially, but I mean, if you want to limit the holding to the facts of this case, that's an easy way to do it, and you just simply rule that when you give up exclusive possession of a portion of your home, it no longer qualifies as your homestead.
Right. I mean, so what you need is first you need the court to agree with you that it's even possible to do the apportionment, right? Because I think that we'll hear from the other side, but it seems like they question that premise. And so once you cross that threshold, then the question is, in this particular case, what was it permissible to, the 15% that's at issue here? And it seems like, whatever your criteria are, this case would meet those criteria. And then all these other things about a home business and relatives staying, ad hoc, whatever. I mean, those are separate issues that could be dealt with, when they're presented in an appropriate case.
Right, exactly. I would encourage you to limit this case to the facts of this case, because the facts lend themselves to an analysis that's quite simple. I would certainly encourage you to go beyond that and try and address all commercial purposes. But at the end of the day, we have statutes that are on point that confirm a single-family residence can be divided between its use as a permanent residence and its use as a place of business or for commercial purposes. 196.0314 confirms that, in that it states the exemption only applies to those parcels classified and assessed as owner-occupied residential property or only to the portion of the property. So the Second District didn't address this statute at all. Ms. Johnson would contend that it only applies to mixed-use properties. The reality is that if it only applied to mixed-use properties, it would say only to the portion of the parcel, not only to the portion of the property. It says only to the portion of the property. If there's any ambiguity or doubt as to whether or not that statute applies to Mr. Rebholz, Florida law requires you to construe it strictly against the exemption and against the taxpayer. When you look at that statute through that lens, then a single-family residence can be, in and of itself, divided.
Counsel, I have a question. Shouldn't we read all the different parts of 196 in harmony? So my question is, didn't the legislature limit the effect of rental of a dwelling on the right to a homestead exemption to situations where there is all or substantially all of the dwelling that's rented in 196.061?
Absolutely, Your Honor. But that statute addresses when you abandon your homestead. You abandon your homestead when you rent all of your property out. Why? Because you're not using it as your homestead and you no longer qualify under 6A of the Constitution because you have to own and maintain.
So then didn't the legislature essentially set that as a floor? I mean, or
set
maybe even as a ceiling, because this is where they're willing to draw the line. All or substantially all of the property needs to be rented in order to lose its homestead exemption status.
Again, that's a very easy analysis because you're abandoning your homestead when you rent out all or substantially all of it.
Right.
Mr. Rebholz didn't abandon his homestead, and he didn't lose his homestead.
But I guess that's why we're struggling so much, and you can hear from the questions on the bench, where exactly is that line to be drawn? I mean, it's very easy, like you said, to draw the line at all or substantially all. But then when you start getting into the nuance of an otherwise exempt property, and now you're going inside and you're like, well, maybe the kitchen is not exempt. Maybe this part of the bedroom is not exempt.
But when you rent out all of your home, the homestead is abandoned.
Agreed.
In this particular instance, the only thing that's happening is that you're paying slightly more tax on that portion of the home that is not part of your homestead or not part of your permanent residence. So it seems to me that 5 out of the 6 judges that have looked at this prior to you have had some sort of fundamental issue with losing your homestead. But there's no homestead being lost here as it would be lost under 196.061. There's only slightly more tax being paid on the portion that is not.
There's only part of the homestead that's being lost.
It's only part of the homestead exemption that's being lost.
Right.
But, and again, it's not even being lost. You're just paying a 7% increase per year on that portion. And I just don't see the parade of horribles from paying slightly more tax on a piece of your property that
Well,
you're.
somebody who's living, month to month and barely able to pay the bills, they might disagree with that sentiment.
Again, if you're using your home for commercial purposes, you don't benefit from the homestead exemption. It's not a homestead and it's not part of your permanent residence, therefore you should be paying more tax on it. Mr. Rebholz would suggest that Section 196, how am I doing on time?
You have 3 minutes and 40 seconds left.
Of my full time or my rebuttal?
Of the full time.
I'll reserve the rest for rebuttal.
Okay, thanks.
Is the clock not working there?
It said 3 minutes, but I think he had intended to reserve 5 minutes for rebuttal, so I don't know if you want to give him extra. Anyway, please to court. My name is Sherry Johnson. I represent Don Rebholz here today. First thing I just wanted to emphasize the court, because I think this is important. The problem here is not with the statutes. It's with the property appraiser's interpretation of the statutes. I've been consistent in my arguments throughout this case. I do not contend that any of the statutes or the rules are invalid because they violate the Constitution. Our disagreement has been over how they're interpreted and applied. The most important one I'd like to address actually is raised by Justice Polston. I really want to address that because if anything were to be resolved in this case, and obviously I hope it's all resolved in my client's favor, but I think one of the most important things this court can do here today is to resolve the correct interpretation of Section 196.012, subsection 13. And that's the definitional statute that defines this phrase, real estate owned and used as a homestead. For years, the property appraisers have relied on that statute in denying a homestead exemption to people who rent portions of their property. And the problem is this statute does not apply to the homestead. As I argued in my brief, this statute is intended to apply to the complete exemptions for disabled veterans. If you look at the statute itself, that's the only reading that makes sense. If you were to express the statute as a mathematical equation, it's the statute says real estate used and owned as a homestead equals homestead property minus that used for commercial purposes. So it is not a definition of homestead property. So I think that fundamentally the court, I hope, will clarify that that statute is not applicable to homestead exemptions. And I'd also emphasize that homestead exemptions are different from other exemptions in several important ways. One, of course, is that the requirements are embedded in the Constitution. The other is that the other exemptions that you look at in these statutes where apportionment is expressly allowed they're all complete exemptions. When you get an educational exemption or a religious exemption or charitable use, or even the disabled veterans and disabled first responders exemptions, these are all exemptions where any portion of the property that qualifies is completely removed from the tax roll. And because these exemptions are so generous, it makes perfect sense to me that the requirement for those exemptions would be more stringent.
So do you think the taxpayer in the 4th DCA case, and I can't pronounce the name of it, was she wrong to concede that the apportionment of her apartment house was permissible?
Yes.
Okay, why?
Yes, absolutely.
Why?
Well, no, I should take that back. I think she conceded that the land was.
No, she conceded that the building. So she had one of the units and all,
Okay.
you know.
Okay,
So
in
I'm trying to understand, is your rule that essentially if the part of the property that's undisputedly where you live is under the same roof as whatever else is going on there, that essentially the property appraiser has to treat the whole thing as your homestead?
No, Your Honor. That's where the enabling legislation comes in. And I have no quarrel with the enabling legislation. That's Section 196.031. Section 196.031 takes the constitutional requirement that the homestead apply to permanent residents and gives it a little more clarity. It says it applies to the residents and to contiguous property. And important to this case and the Carey-Yanakis case, it also says that the homestead only applies to those parcels or the portions of the parcels that are classified and assessed as owner-occupied residential property.
So then your reading of 196.0314
Yes.
is consistent, as the Chief was saying, with an excludability of some room or several rooms in a home, right?
No, not within a home.
All right, so help me understand where the limiting principle is, because it seems like what walls we build around a space is a fairly thin reed upon which to hang someone's constitutional protection to a homestead exemption, because we can, plaster a room, in a day or two and call it under the roof when it's, or put it underneath a extension of a roof. It seems like if 196.0314 puts the burden on the person seeking the exemption, because as an initial matter, all the property is taxable, and allows the property assessor to say, we'll tax everything except what is owner-occupied residential property, or only to the portion of property so classified and assessed, it would seem to me like they could do it within a room. What's the magic of enclosing it with walls?
Well, I think it's a combination of the statute itself and the voters' intent in approving the Constitution. When we look at the statute itself, and it talks about the classification of property, I believe this was the legislature's way of trying to ensure that people couldn't claim a homestead exemption on commercial property.
I'm not interested in what the legislature or the voters intended. I'm interested in what they did. The words here are the deal. So without getting into what the voters intended or what the legislature intended, help me work with the effect of these words.
And the effect is that in order to apportion property, the property appraiser would have to have classified the property as something other than owner-occupied residential property, which they could have done. If this property were classified and assessed as hotel, motel property, or I think they actually do have a classification for, boarding houses. If they had done that, if this property were actually taxed, classified, and assessed as some type of commercial property, then absolutely.
So if your client had come in and told the property appraiser exactly what's going on, I have this house, I've designed it so that on the top floor I can have these 4 kind of independent units with the laundry room and whatever, I'm going to be renting them out, et cetera, the property appraiser would have been within his rights to say, okay, great, that falls into this classification. You get a homestead on the 85% that's your quote-unquote residence and not on the 15%. That would have been okay.
If, and this is where we have a disagreement here, I've never conceded that this was a commercial operation or a boarding house in any way, shape, or form. The trial court looked at the evidence. They obviously did not find that. The second DCA reviewed the evidence. They agreed. If this were actually a boarding house type situation, a bed and breakfast, wherever you got services, you got your
But
breakfast.
but if the facts are the way this seems like this to me has proceeded on the acceptance of the facts of the 15%, and it's truly rented out, and the one guy was there for 15 years or whatever. And the problem that the courts have been struggling with is over just the propriety of apportionment in the period, regardless of how that was being used. So it sounds like what you're saying is that if we accept those facts as true, if the property appraiser had known on the front end what exactly was going on in that house, it would have been okay to deny homestead to the 15%.
No, in this case, because it's not just a matter of knowledge. Even after he knew how the property is being used, he still classified it as a single-family residence. You know, if someone
Didn't
goes
they immediately impose the lien and all that? I mean, it seems like the statute that allows for the correction, the 10-year look back when something got a homestead exemption that it shouldn't have, that kind of assumes that if there's a mistake in the classification, especially one that's based on what was presented to the property appraiser. This isn't like, the case we had where the property appraiser treated the one parcel, left out some of it or whatever. I mean, it doesn't seem like it would make any sense to allow the taxpayer to not give a full picture of what's going on and then use the misclassification as the reason for why it can't be fixed by the property appraiser when the statute requires the property appraiser to fix it.
Okay. Two things. First of all, there is a difference between the reclassification of property and the removal of homestead exemption. Classification refers to how the property is taxed. For example, hotels and motels are usually assessed by the income approach. Single-family homes, usually by a sales comparison approach. Just taking away a homestead exemption does not reclassify the type of property that it is. They can't do that retroactively under the statutes. Secondly, as far as, the practicalities of a property owner conveying this information, the homestead exemption application doesn't ask anything about how many rooms you're using or if you're renting anything. There's no mechanism in place for any of this. An average homeowner, and believe me, I've got lots of clients in this situation with all variations of this. The average homeowner who's renting a room to someone, there's no opportunity when they apply for the exemption to say, oh, we're only living in two, we're renting out one. They're being set up to fail. The only way these issues are ever addressed is retroactively by imposing a lien with back taxes, penalty, and interest. So as a practical matter, if a person were to go to the property appraiser and say, I just want to let you know in abundance of caution, my attorney told me to tell you that I'm renting a room to someone. Does that mean the property appraiser can go away and remove the exemption from that? I would say no. Because again, if it's a single-family residence and it's classified and assessed as a single-family residence, the statutes nowhere allow the property appraiser to apportion out the portion of their residence that is being used for, allegedly commercial purposes. And I would note too that in their reply brief, in the conclusion, the property appraisers talked a lot about the specific facts of this case and the lease, which I don't think is dispositive at all in the length of time. But I think these arguments are a red herring because the property appraiser made it clear in their brief they believe rental of a room justifies removal of the exemption on the room that's rented. Their position is very simple that way. They also said, which I thought was intriguing and problematic, that they do not necessarily consider a home office to be a commercial use. And to me, that actually makes this position worse because what we're saying is if you're a white-collar executive that runs a business out of his home, you're fine. You don't lose your tax benefits. But if you're a senior citizen on fixed income or a working woman who cares for other people's children in your house, then you have to worry. And that's not right. We should be treating everybody equally under these statutes. And I think the enabling legislation, the way it's written, allows that to happen. If you just focus on the type of property, is it commercial property? Is it multifamily property? Is it a single-family residence? If it's a single-family residence and you have a home office, you're renting a room to a friend, relative, buddy, I don't think that changes your right to this exemption at all.
How does your argument there not read out of the statute 1960314? Save that provision of the statute, given what you've just argued.
I'm sorry, I'm not sure I understand your question.
1960314 says the exemption provided in this section applies only to those parcels classified and assessed as owner-occupied residential property or only to the portion of property so classified and assessed, right?
Right.
So if that statute is going to make sense, if we're going to give effect to those words, it must be the case that the legislature, in fact, did imagine that you could apportion a residence and say some portion of this residence is not owner-occupied residential property, right?
Yes.
Okay.
Well, not a residence. I mean, I think a residence is a residence. If it's, let's say you've got a convenience store and there's a living quarters up top. Or when I was a kid, we lived in a motel. We had a 10-room motel and have a living quarters on the back. Obviously, that could be a portion. You've got a commercial use in the front. You've got a residence in the back. I don't see, if it's a single-family residence and it's classified and assessed as a single-family residence, then no, I don't see the ability to apportion. And I also wanted to acknowledge your point.
Why not? I can't, I'm struggling to understand why that couldn't be apportioned in the same way that the other things you have said can be apportioned.
Under the statute, the only way it can be apportioned is if it's classified and assessed as something other than owner-occupied residential property. And I think, going to Judge Carroll, you raised earlier the question of possession, exclusive possession. And if the legislature intended to deny a homestead exemption because you gave up possession, why did they enact Section 196.061, which expressly allows people to rent the entire property? I mean, essentially what you'd be saying is that a person who rents out their entire property is fine, as long as they do so for 30 days or less than, but not.
But none of that helps so it sounds though like you've gotten to the point where you're conceding that this is not a constitutional case. I mean, it sounds like you're saying to me that there's nothing in the constitutional definition of homestead and the exemption and everything that would preclude the apportionment, that it's completely a question of the statutory framework and the timing of when the property appraiser. So if this were completely, if your client, if Mr. Rebholz were still alive and the question were prospectively going forward and the property appraiser knows everything, based on the argument that you've presented, it sounds like there would be no problem with the property appraiser saying, okay, 15% is commercial, 85% is your residence, and we're going to tax you accordingly. That sounds like what I've heard you say.
If the property appraiser treated this as a commercial property or a mixed-use property, then yes, he could have apportioned it. But he didn't. He always treated it as a single-family residence. And that's my position, is that if it's a single-family residence, I don't see anything in here that would allow the property appraiser.
So in your mind, the case is really just about how to fix what it sounds like you're conceding it was a mistake. That it could have, that it should have, I mean.
No, I don't think it was, because I don't think this was a commercial property.
Okay, I mean, I don't think you're going to.
It's mixed use?
Yeah, I mean.
No, I do not. I do not. When we talk about how he used this property, he had a lease. Anybody, I mean, who came to me and said they were going to rent a room, I would encourage them to have a lease. I don't think that makes it a commercial use. The rooms, okay, so they had locks on them. My bedroom has a lock. I mean, that, to me, there was nothing about this property that struck me as a commercial property, and obviously the trial judge and second, agreed with that. If this were in fact the type of property, like a bed and breakfast, where he served breakfast and wine in the evening, and there was house cleaning services, but that's not what this was. There was one entrance, a common area. These rooms didn't have appliances, their own washer, dryer, anything like that. They were, they were bedrooms. I don't see that as a commercial operation any more than any of the other clients I have who are renting, one or more bedrooms, just to help make ends meet. And I mean, the reality is, the people that do this, this case is not an anomaly. A lot of people in this situation. Sometimes you get people whose tax liens exceed $100,000. That's one thing. But most of these people are people who get tax liens of like $40,000 or less. They certainly can't afford to litigate a case, to the Supreme Court of Florida. So, I would just suggest to you that this issue it's going to be hard to get before you again. And there's a lot of people in this situation who are renting rooms, and, you know, under the property appraiser's interpretation, they consider that a commercial use. So these people would be facing enormous tax liens, and that's not what the voters intended in the Constitution. And I think that is important. You know, if you look at when the voters approved the Constitution, did they honestly intend to say that if they rented a room that they could get a tax lien for back taxes, penalties, and interest because the property appraiser didn't know they rented a room? I think that's crazy. I don't think there's any way that the voters of Florida intended that, especially back in 1968 when, honestly, it was a lot more common to have, you know, boarding houses and such back then.
I mean, the other way of looking at it, though, is do the voters want the tax law to hinge on whether I own a rental property and make money from it that's completely separate physically from where I live versus if I do the exact same thing but segregate a portion of the house? And would they want that to be a difference that causes the taxation? I mean, there's obviously the you know, fairness and equality aspect of the tax laws too, right?
There is, absolutely. But the voters, you know, I think their intent was pretty broad. If you look at the Constitution, although the legislature never acted on it, the voters actually approved having an exemption for renters. So when this Constitution was approved, I think the voters, you know, actually had a fairly broad intent as far as who should qualify for a homestead exemption. And that, like I said, I think that's important because this, again, it's not like the other exemptions. This isn't a complete exemption. It's just really a discount, you know, essentially is what it is. The problem is that these situations, they're only going to come up retroactively. So from a practical matter, you're looking at a lot of people that could face some huge tax liens for something that...
I mean, the irony is if I were sitting at DOR listening to this, I would be thinking maybe we need to make the forms more robust, and your arguments could end up causing a lot more people who are in this sort of gray area that sort of fly under the radar to have things that are commercial uses actually identified on the front end. Well, whereas this is a pretty stark case that would meet, I think, any reasonable definition of something that's, you know, commercial and not his residence. It seems like you're not doing people any favors by suggesting that what we need is more kind of front-end scrutiny on that.
Well, I believe in transparency, and from what I've seen, the property appraiser ultimately finds out about these issues. And when they find out about it 10 years down the line, you know, that's obviously can cause catastrophe for taxpayers. So I do think that if that were the law, it should be more transparent. I don't think that's the law, though, obviously. Sorry. Sorry, I lost my train of thought there for a second. But in any event, I think the bottom line is that the Constitution talks about a permanent residence. There's nothing in the Florida statutes that talks about carving up that permanent residence. And if the voters had wanted that, they could easily have done so. The other exemptions in the Constitution specifically talk about apportionment. Article 7, Section 3 specifically, when talking about educational, literary, scientific, religious, and other exemptions, specifically says that it should only go to the portions of property that are being used that way. That language could easily have been used here, but it wasn't.
Thank you.
Thank you.
I know I only got a couple of minutes. In regard to 196.0314, that statute does not say classified and assessed as single-family residential property. It doesn't say single-family. It says owner-occupied.
What do you make of the word parcel in that provision? Can you give me a use of parcel that means a room as opposed to a piece of land or as a show me? Like,
I don't think a room does represent a parcel.
Okay, so then how do we help me understand how your argument helps you out there?
Not a problem. 196.0314 confirms that the exemption only applies to the parcel classified and assessed as owner-occupied residential real property.
Or only to the portion of the property so classified and assessed.
Right, but it doesn't say only to the portion of the parcel. It says only to the portion of property. So when you're looking at a parcel, and everybody agrees that that statute fits nicely into the Karianakis analysis and everything else, so we know it applies. So it's easy to say, look, this parcel, this apartment, in this apartment building, that is a single-family residence. It is a homestead. The rest of it is not.
How do you respond to their argument about how you're only catching this on the back end?
Well, I think that's why this bothers so many judges. But the reality is that the tax lien is mandatory. When there's a violation that's discovered, the property appraiser shall record a lien to recover the back 10 years. That is a mandatory determination. My client has no discretion in that. Nothing's more certain than death and taxes. I hate to go there, but that's what we're dealing with here. If there needs to be a rewrite of that law, the legislature needs to do it. But the reality is that the tax lien is absolutely mandatory. To go back to 196.0314 for a second, if there's any doubt as to how you would apply a parcel or a portion of property to Mr. Rebholz's situation, there's already been a concession that that statute does apply to apportioning a parcel of real property that has multiple uses. If there's any doubt, if there's any ambiguity as to whether or not that statute applies to Mr. Rebholz, the law says you strictly construe it against the exemption and you strictly construe it against the taxpayer. That's where the analysis can stop. Thank you.
Thank you both. We'll now take up case number 21-1204, Tomlinson versus State of Florida.
Good morning, Your Honors. I'm Daniel Tibbet. I represent Kevin Tomlinson. This may seem at first blush to be a simple statutory interpretation case. This is a free speech case. Everybody who wants to speak out in this country, at least in this state, whether for or against any public or private figure, will be affected by this decision. You cannot commit the crime of extortion without speaking to somebody, without communicating the supposed threats at issue. This country has always afforded people the right to communicate, to speak. Our founding fathers obviously enshrined that right in the First Amendment to the Constitution. This is the case despite the fact that by definition, speech that the government seeks to prosecute is speech that the government does not like.
If this is a free speech case, why don't you cite the First Amendment anywhere in your brief?
The brief and the brief does talk about the speech issues and the entire overbreadth, vagueness.
I'm looking at your table of contents, and I don't see a citation to the First Amendment to the United States Constitution. Am I missing something?
I'm not sure what's in the table. I came into this case, I did not personally write the briefs in this case. However, the case cara carte from this court that this case stems from was a case where there was an overbreadth vagueness challenge. That's discussed at length in the briefs, and the
So here's what we said. Here's what we said in cara carte. Quote: Defendant's contention that the extortion statute is impermissibly vague by virtue of the term malicious is without merit. This court has repeatedly upheld the terms malice and malicious against a vagueness challenge. So it's a vagueness case, right?
The vagueness challenge is that's ultimately a First Amendment.
We can talk about the First Amendment, but it seems to me like what we as a court need to decide in this case is what maliciously and malice means in the context of a criminal statute, and whether malice here means malice in the legal sense, namely, as you and your opponent have briefed, malice in terms of intentional action in an illegal way, or malice in the sense of hatred. And it seems to me like before the notice you filed this morning, everything we had been reading was about that question. So I'm kind of interested in solving that one before we start talking about the First Amendment.
Well, I think they're related questions. I think if the court looks at the statutory interpretation question of what does maliciously mean in this statute, it's not defined in the statute. The court in Caracarte cited to this court's decision in Gaylord that found the same maliciously language that was not defined at that time in the child abuse statute to mean actual malice, to mean that you had to act with ill will. Then the legislature came in and said, no, that's not what we meant for child abuse, and they put in the statute for child abuse maliciously means legal malice. They never did that in response to the Caracarte decision with extortion. The difference between child abuse and extortion is that child abuse does not, there's no constitutional amendment that's implicated in, you don't have a right to abuse your child. You do have a right to speak. That's why when the, statute is somewhat ambiguous, the First Amendment comes into play, because the court has to realize that the whole point of Caracarte was to protect the extortion statute from a First Amendment challenge, from the entire statute being invalidated because it was, overbroad and vague and ultimately violated people's First Amendment rights. So, without a...
I'm struggling to understand how the First Amendment issue relates to the question that's actually presented here about whether malice means actual malice or legal malice.
Well, the way that it relates is that actual malice protects the statute from being unconstitutional under the First Amendment, because it sets a high, the First Amendment has the whole true threats thing. You cannot, you can...
And you, sir, you argued this in your brief? You argued that the statute was unconstitutional in violation of the First Amendment?
No, I don't think the statute is unconstitutional in violation of the First Amendment.
If we interpret it the way you think we should interpret it. And this was argued in the brief.
No, I do not think that the statute is unconstitutional. I think that the statute has an actual malice component, and it has been long held that you cannot, or that you can criminalize speech that has an actual malice component to it. So I'm not...
I think what we're getting at is that a lot of the cases that you do in fact cite and that the government has joined issue with are actually not free speech cases at all. They're due process cases. Vagueness is about when, because an act, a legislative act, speaks with unconstitutional breadth, it criminalizes conduct without notice to me. Right. That it is in fact criminal conduct as understood, because it is, violative of, the law and what has been enacted as a guide to, legitimate behavior. That's not a First Amendment question. That's a due process question. And I don't know how this whole discussion helps you win the case at all. What I was hoping we would engage in, and what I think we still have time to engage in, is a discussion about what to do with the question presented, whether there is a sufficient guide if we say that the statute criminalizes malice in the legal sense to people's behavior, so that prosecution can happen in a way consistent with due process. That's what I think the issue is in this case.
Okay. As to that issue, I think that with a statute not telling people what is the malice standard.
Do you accept the premise that at common law extortion just required what we're now calling legal malice?
I accept that.
I think if you
extortion
accept
common
that
law-
premise,
I'm sorry?
if you accept that premise, then I think the constitutional stuff goes out the window. And what you're left with is, what did the legislature do when they used the words that they used here? Either choice would be constitutionally permissible. Does the word that they used mean legal malice, or does it mean actual malice? I mean, I think you started off by saying this isn't just an ordinary statutory interpretation case. I think that your strongest case is to make it a statutory interpretation case. And so the question for you is, why, given the tools that we normally apply to understand words in statutes, why should we read the word maliciously here to mean actual malice rather than legal malice?
Okay, well, let me just say one thing.
Counsel, I'm sorry. I'm going to jump on you a little bit here, too. Don't forget his question, but I have a follow-up question to that. Our common law understanding of malice has historically been legal malice. Would you agree with that?
No, I would not. What I was agreeing with in Chief
So
Justice...
you do not, hang on, you don't agree with that. Okay, so our common law understanding of malice, you say, if you don't agree that it was legal malice, you're saying that it's actual malice, historically.
Well, that issue was not briefed either. What I was talking about with the common law extortion...
Whether it's briefed or not, this is my question to you. Would you agree with that premise?
I have not researched the common law
so
history
take my word for
the
it.
word
So
malicious.
historically, common law has treated malice as legal malice. And when we use words in a statute, it is presumed that we use the meaning that was given at the common law, unless the legislature specifically says we're going to adopt a different meaning. So if that is all true, why then should we interpret in this statutory context the word malice to be actual malice instead of legal malice?
Well, I think that the premises that Your Honor is coming from, if you look at the common sense definition of malice, what people understand malice to be, it is not just intentional. And when you're talking about giving notice to people of what is prohibited, what is not prohibited, when, someone's talking to another person on the street, when they say someone's acting maliciously, they don't mean, they did something intentional. They mean they did something evil. They did something motivated by spite.
Well, let's talk about the dictionary interpretation of malice. If you look at Black's, dictionary, if you look at all the Merriam-Webster, in the legal context, what the first definitions that they lay out are always the legal definitions of malice. I think, if memory serves me correctly, there's only one legal dictionary that says, and there is also actual malice, but it doesn't lead off with that.
I mean, every dictionary that I've looked at, including Black's, has talks about both definitions. So I'm not sure. I don't agree with the premise that every dictionary only talks about the legal malice. But what I'm saying is, and the cases say this too, that actual malice is the common sense understanding. When you're looking at interpreting a statute, a criminal statute, and giving people notice of what is allowed and what is not allowed, I think that the court needs to, and the court has said that you should look at, what are we notifying people of? If the legislature came out and said, okay, what we mean by malice is just intent, then we have a different issue. Then someone's going to challenge it on the grounds that I was talking about before, and the court would make a decision. But since they haven't said that, I think the defaults should be what is a common sense understanding of the statute.
The Chief's question.
Yes. So I'm sorry. Can you repeat? Because I got lost when I got asked another question. Can you summarize for me?
No, I think I mean, it's kind of what you've been talking about, which is basically using the normal tools of statutory interpretation. So we have the canon about the common law meaning. We have the ordinary meaning canon. I mean, are you saying that we should basically, because of the notice issue here, go with the ordinary? What you're saying is the ordinary meaning rather than the common law understanding?
Thank you for refreshing my memory as to your question. It's a good question. I think that's part of it, but also if you look at the actual statute, the actual language of 836.05, which, I think everybody agrees that the starting point for any statutory interpretation is, what do the words say? It has two separate limiting clauses. One of them is for the extortion that it has to be maliciously, what we're talking about. The other one that specifically says, in the statute, it has to be done with the intent to, intentionally do wrong to somebody, essentially. So, the government, the state, is equating those two things. If the court says maliciously in this statute is just legal malice, the word maliciously does no work because the statute already has the other clause that talks about intent. So, the legislature does not, and this court does not presume that legislatures, put words superfluously into statutes. The fact that they wrote maliciously as an additional limiting factor on when criminal penalties can be applied to somebody in addition to, the intent language that's in the statute tells the court that the legislature wanted more before they were going to punish, before they were going to approve punishing Floridians for speech. So
I mean, if we just concentrate on the ordinary meaning of the word, maliciousness, it just seems to me, just without looking at anything else, just thinking of the ordinary meaning of the word malicious, to me, it would include something like Black's dictionary says, which is ill will, wickedness of heart. Something more than just doing it. It seems to have, the word malicious to me seems to have that component to it. Something wicked this way comes when I do this. Right. That type of thing. So that seems to be your strongest argument here, it would seem to me.
Yeah, I mean, I think you're, Justice LaVarga, I think you're right. I think when any two Floridians are talking to each other and somebody says, oh, this person did something malicious, that's what they mean, and if that word is in the statute, absent further guidance from the legislature, it should be interpreted that way.
It would have been nice if the legislature had said when we say maliciousness, we mean X, Y, Z.
Right, and they know how to do that, and they did that in the context of the child abuse statute after this court ruled in Gaylord and in Reed. So
Counsel, what would the jury instruction under your reading of actual malice? What would the jury be instructed? What would the jury have to determine?
You must find that the defendant acted. It would. I mean, it's in the current one as one of the current jury instructions. I understand why the court took this case because it doesn't make a lot of sense to have a standard jury instruction that tells a trial judge, well, choose one or the other. But it would be what's in there right now as the actual malice option, which is you have to find that they acted with ill will, hatred, spite, evil intent. I think there's four. There's four words and it's or four phrases and it would be what's in there right now, and that's what it should be. And that was argued at trial, and the defendant should have an opportunity to have a jury determine beyond a reasonable doubt whether the state met that element in this case. So we would ask the court to reverse and remand and to hold that extortion requires actual malice.
Good morning. May I please the court? My name is Ksenia Smuchkovskaya, Assistant Attorney General, appearing on behalf of the state of Florida. Legal malice is the proper standard for extortion. Extortion is about greed, not hatred. The purpose of the extortion statute is to prevent one person from unjustly enriching himself by threatening another's person, property, or reputation. The extortion statute does not state that the criminal conduct must be motivated by ill will, hatred, or evil intent. Instead, it requires that the offense have been committed with the intent to extort money or pecuniary advantage.
Counsel, let me ask you this. You would concede that ordinarily, in interpreting a statute, we first look to the common sense of the words being used.
Your Honor, we do look at the text first,
Pardon?
correct? We do look at the text, at the term.
I understand, but we look at the words and the common sense of the words that are being used. Is that correct?
Correct, Your Honor.
And so, and you would further concede that the sense of that you are advocating for here, legal malice, is not the common sense of the term malicious, right?
No, Your Honor, I would disagree, because if we look at the term maliciously in the context of the statute, the ordinary meaning of it would be intentional and unlawful. We no longer look at the statutory term in isolation when we interpret the statute. We look at the specific context that term is used in the plainness.
So you're saying the context here would point away from the common sense of the term to a technical sense, which is legal malice, right?
Correct, Your Honor, but I would still argue that common sense here is more wrongful. The ordinary meaning is wrongful more than with evil intent.
So if I understand your position, Ms. Smishkuskaya, it is that this word just has two meanings, right? And both of those meanings are pretty old, and one of them is perhaps more common in colloquial usage. But there's another perfectly good meaning to this word, and it's an old usage, and it means with an illegal intent. Is that a fair rephrasing of your argument?
Yes, Your Honor, but also the respondent is arguing today that based on the context of the statute and that mens rea provision included in the statute, it gives the different meaning to legal malice.
Because this appears in a statutory text about extortion, we have a textual clue about which of these words well-recognized meanings to use. And that is the one that means with an illegal or impermissible, ill will kind of intent. And then, if I'm understanding you correctly, the statute goes one step further and says, by the way, because an element of the crime is to demand money, then we know that's more evidence that we should use this other meaning of the word malice here, right?
Correct, Your Honor, because we must exhaust all the textual clues when we interpret a statutory term.
But going back to Justice Kennedy's commonsensical approach to interpreting the word malicious. See, when I think of the word malicious, I'm not thinking about intent. I'm thinking about somebody doing something ill will, something wicked, something not even illegal. I don't even think about illegal, just something wicked, something in that sense of the word. That's what I think about malicious. So now you'd want us to say, well, it actually means intentionally, it actually means illegal. I don't get that from the ordinary sense of the word. If you want to change the meaning of the word, I guess that's fine, but that's not my sense of it.
Well, Your Honor, interpreting the term maliciously in the context of extortion would lead to absurd results, because first it would essentially prohibit penalizing the extortion of strangers or the victims with whom the defendant appears to have positive relationship with. It would also lead to or even encourage defenses and arguments that are solely based on subjective feelings of a defendant instead of a pecuniary interest. Extortionist conduct is driven by greed, by desire to take advantage. It's not a personal crime. It's not about hatred. In fact, nearly every district to consider the question agrees. The legal malice is the proper standard for extortion.
But let me ask you this, and this has to do with the question of exactly what actual malice means. Does it necessarily require hatred, or can it just be some other? Obviously, hatred involves an evil purpose, but can it also involve just a different sort of evil intent?
Your Honor, actual malice is defined as evil intent, ill will, hatred, or spite.
But those are alternatives.
Correct.
It covers kind of a range of things that include evil intent as one of the things in the range of what it signifies.
Your Honor, including actual malice definition in the jury instruction might cause more confusion. What is evil intent then? How evil needs to be the intent in the context of the crime of extortion?
Well, we have,
Yeah, I mean, so, go ahead.
The crime of extortion includes to basically threaten to expose another to disgrace, basically to impute any deformity or lack of chastity to another. And all those crimes seem to have some type of component of evil intent. And me threatening to expose person X to the fact of lack of chaste character or something like that. That seems to me a commonsensical approach to it.
However, to penalize a defendant's or perpetrator's act or behavior, that type of behavior needs to be unlawful, not just full of hate, not of spite. The measurement is, does the extortionist has a lawful right what he's demanding or what he's claiming? I think it is really important that there is a mens rea provision that guides this court, that the intent is to extort and get money.
Well, but how do you answer counsel's argument that based on what else is in the statute, that under your interpretation, or the interpretation you urge, that the malice isn't really doing any work because it's already in there? What legal malice would signify is already embedded in the other provisions of the statute. I think that's counsel's argument, right?
Well, not necessarily, because in the mens rea provision, it's the intent to extort money, but it needs to be an unlawful act, unlawful threat. Someone should have no legal right to demand money. So I not necessarily agree with the counsel's point. And besides, at common law, the crime of extortion never required actual malice.
So in this case, if the defendant had been promised some contractual percentage of a listing, and he had said, I'm going to go public with the fact that you breached this contract, then he could not be prosecuted for extortion, right? Because he would have a legal right to receive what he was demanding. Is that fair?
He would have a legal right to obtain the money and demand the money.
So then the work that the word maliciously does is it excludes that case from prosecution, right? Am I understanding you correctly? Okay.
Could you talk about, it seems like your case, if we have the lenity issue that's kind of hovering there in the background, that we know that it comes in kind of at the end of the interpretive process, but it seems like you're asking us to put a lot of weight in this kind of common law canon as a trump of the ordinary meaning canon, because if they were kind of equally plausible understandings of the term, and there's either side could point to a canon, then you would think that lenity would require us to side with the defendant. Why is that wrong?
No, Your Honor. The respondent urges this court to look at the text and exhaust first all textual clues. And by looking at the text, we see the mens rea provision, and it's respondent's position that it does clarify. The focus is on the intent to extort and money.
But you keep assuming what the whole case is about. I mean, unless you say that, really to say that the relevant context is that it's a criminal statute, basically you're just saying that that any time you're dealing with a criminal statute and there's an established common law understanding that basically becomes the clear meaning of the term. I mean, it sounds like that's really what you're wanting us to say.
It's one of the arguments, Your Honor. However, also the canon of interpretation of the statutes to make sure they don't lead to absurd results, the respondent suggested as well. because it would eventually allow extortion of strangers or the victims that defendant never met in person, doesn't have any subjective feelings against.
I don't understand how that is consistent with the element of, in the definition of actual malice, it requires evil intent. Because you can have an evil intent with respect to strangers.
Well, Your Honor, I think the actual malice have that subjective component to it, which is legal malice is very straightforward, intentional and unlawful threat with the intent to extort money. And as Justice Muniz has pointed out, the rule of lenity comes to play only after all the interpretive tools have been used and exhausted. And I don't think this is the case where we need to even go there, just based on all the clues are given by legislature in the statute and the common law definition.
But you do have this issue that this is not the sense you're urging, may be supported by the common law, but it is contrary to the common sense of the term, which is where we start. So, I mean, it's an interesting case. I mean, because you've got these different things that play into the interpretive question, but we have this statutory directive from the legislature to apply this rule of lenity. So that's
and really, I mean, criminal statutes are an area where, arguably you would be disinclined to kind of go with sort of a technical / expert understanding and maybe shade things more towards sort of the person in the street who's, the average person running around doesn't have any clue what the common law understanding of malice was.
Well, Your Honor, going back to the rule of lenity, the respondent doesn't believe that even the application of rule of lenity will necessarily is in petitioner's favor. First, under the case of this facts of this case, petitioner acted both with actual malice and legal malice in this scenario. So the facts of this case are unique. Both of the definitions would have resulted in the conviction. And there could be scenarios where actually the persecution would be in position where it would be easier to prove hatred instead of legal malice. So then not necessarily the rule of lenity would result in the what the petitioner is asking here today.
Well, but you certainly think that the other standard would be more favorable to the actual malice standard in this case would be more favorable, right? And in general, wouldn't it be more favorable to the defense?
I think it's very case specific, Your Honor. It really depends on the content of the communications that the extortion is made. It's very case specific and applicable to this case. I think the acts of petitioner and the threats made in this case, both standards, actual malice and legal malice, would absolutely justify the conviction in this case.
Go ahead. I mean, legal malice is a subset. I mean, wouldn't every case that satisfies actual malice also satisfy legal malice, but not the other way around?
Your Honor, there could be scenarios, again, where there are threats full of hate to extort money and where the state would be able to prove hatred, but those communication would be legal, certain demands that the other party would be entitled to demand, whether it's a contractual obligation. I hate you, I will sue you, right? But if there's a contractual obligation, if one hates the other person, is still entitled legally to that money, but it's full of hate, the state can establish hate. Does the communication contains hateful threats, other lawful? Well, that person is entitled to money owed. So I think it's very factually driven. So not necessarily the rule of lenity weighs in petitioner favor in every scenario.
Could you address the issue? Say we disagree with you. I don't know that we will. I don't know that I will. But say that happens. So then we get to the question whether the impact that this error had in this case. We explain why even if the instruction was wrong, that here there shouldn't be a reversal?
Should be or shouldn't be?
Shouldn't be. You don't want a reversal, right?
I don't want the reversal. The third district absolutely is correct. In this particular case, again, the facts of this case is that petitioner acted both with legal malice and actual malice. He acted out of hate and spite and jealousy, and his threats were intentional and unlawful. So based on that, his conviction should be affirmed.
So your position then is the jury would have convicted them anyway?
That's correct, Your Honor.
Under either
Absolutely.
scenario?
Absolutely, Your Honor. And if this court doesn't have any further question, respondent respectfully asks that this court approve the third stage decision.
Okay. So first of all, as to the common law issue of what did extortion mean in common law, I guess I learned something by reading the state's brief, but I don't think that has anything to do with this case because the extortion crime at common law was a completely different crime having to do with public officials seeking benefits or something. So it doesn't mean anything about what the common law understanding of this crime that we're talking about is. So I'd say that. As to the idea that there's going to be, well, the state talked about all the, some lower courts have said, well, this is not a crime about hatred, this is a crime about greed. A finding that that the state has to prove actual malice is not inconsistent with this. It is not my argument that everybody who is guilty of extortion must, hate their victim. If someone, you have the prototypical scammer that, maybe, a stock guy that's getting on the phone and, working at a boiler room or whatever, and he's trying to get, he's just trying to get money and putting people into terrible investments. He doesn't hate those people, but he's acting with an evil intent. He knows that what he's doing is not what he's saying to those people. He would have, actual malice. But the state, that's an element of the crime. So
how do you respond to the issue of that the state in this case proved malicious under either interpretation and the jury would have convicted them in any way?
Well, that's just not the way that the law works. If a jury instruct, if the court gets an element, if the trial court gets an element of the crime wrong, then it's the state's burden. It's fundamental error, and if that element was disputed at trial, then it's reversible. The only time it's not reversible is if the element was not disputed. In this case, the defendant's intent was the entire issue at trial. There was no doubt about what happened. It was recorded. His whole argument was basically that, I was trying to engage in, I was basically acting like a civil lawyer before I got a civil lawyer, and I was trying to settle, this real estate complaints via this proposal that they pay me, and I go and drop the complaint. So his whole argument was I wasn't acting with, evil intent. Now, what would the jury find? I don't know, but we need to find out. We cannot just assume that, he's guilty because the jury found that he had intent, the wrong standard. And that's what the cases say, is if the element is wrong and if it's disputed, it's reversible. The other thing I would say about the absurd results argument the state's making, look, I know the court doesn't obviously love my First Amendment issue argument, but if the court makes this standard legal malice, this is about speech. Extortion is about speech. There are going to be challenges based on the First Amendment, like there was in Caracarte, which does cite the First Amendment. And that would be an absurd result if then, the whole extortion, whether it's, legit extortion or not legit extortion, gets, found to be unconstitutional by some federal court down the road. So, I do think that's something the court should keep in mind. So ultimately, the court should settle this split. The court should give trial courts guidance, and the court should follow the common sense definition that what people mean when they say malice. and hold that the correct standard is actual malice and should reverse and remand.
Thank you.
Thank you.
We'll now stand in recess for 10 minutes.
All rise.
Sometimes I get they won't do that.
He was given the appellant really vicious hard time. And so when the appellant was over, instead of sitting back there and something, we went back in like the theater seats, the way the jury is set up, and he sat there with his head in his hands. The appellee gets up and says, "Oh, I agree with whatever the court just said. Why they broke, don't fix it." And Judge Barker says, "Hey, you got any rebuttal?"
I would not want to be in that guy's shoes. No.
See how this goes.
Yeah. It'll go fine. I just have no idea what they're going to do.
I'll tell you, particularly on those two penalty issues, I wish I was arguing this in the 90s.
Yeah, that's the thing.
Imagine having,
It does depend on who you think.
imagine having Justice Marquette on the bench for those issues.
Yeah. Or even Harry.
Harry, as far as I was trying, it was impossible not to interrupt her. She never knew any questions.
Yeah. I kind of like that because maybe
All rise.
think about it.
Supreme Court of Florida is now in session. Please be seated.
Our third and final case for today is number 21-1070, Figueroa, Sanabria versus the state of Florida.
May it please the court, I'm Steve Bulletin from the Public Defender's Office in Bartow. I represent the appellant Reynaldo Figueroa Sanabria. I would like to argue first phase issues 1 and 2 and penalty issues 3, 5, and 6, but experience tells me there won't be near enough time. So any argument or portion of an argument that I don't get to, I will rely on my initial and reply briefs. Also, ideally, I would like to argue penalty issue 8 because the court's misreading of Pulley versus Harris resulted in the abandonment of proportionality review in the Lawrence case, which in turn leaves Florida's capital sentencing scheme without adequate safeguards against arbitrariness, so it no longer complies with the constitutional flagship Furman decision. But this court has summarily rejected that constitutional argument in the Michael Gordon case. I would ask...
If we were going to re-examine the proportionality issue, would this be a really good case for that?
Not the best.
Okay.
Not the best, but I still think the court should do it.
I understand.
Okay. For a period of 5 years before trial, spanning 3 presiding judges and a succession of prosecutors, there was an intractable conflict between Figueroa and his first phase attorney, Keith Hammond. I want to make it clear, because that I am not in this direct appeal, I am not arguing IAC, not arguing ineffective assistance of counsel, either on the face of the record or otherwise, because under the Blanco and Steiger decisions, I can't. I am also not arguing failure to hold a Nelson inquiry. Problem here is there were Nelson inquiry after Nelson inquiry after Nelson hearing, Nelson hearing, Nelson hearing, and they all resulted in kicking the can down the road. And the problem was at some point, given the this is not a typical case where the defendant comes in there and says, I don't like my lawyer, I don't trust my lawyer doesn't come hold my hand enough. This is not a case like that at all. And one of the many reasons it's not like that at all is because pretty much everything Figueroa said was seconded by the attorney Keith Hammond. I mean, he often agreed with what Figueroa was saying, and basically made excuses having to do with the press of his small private practice.
Can we talk about Jackson, though? How is this case different from Jackson? From just before we get to the merits of their relationship, let's just talk about preservation first.
Okay.
How is this case different from Jackson?
Now, are we talking about the Bertha Jackson case that we're talking about?
I'm talking about Jackson versus State, 983 Southern 2nd 562, our 2008 decision.
Yeah, I believe it's the same case. Preservation.
So in that case, there was a defense counsel who was absent for a significant piece of a victim impact statement. And when counsel came back on the phone, no objection was filed concerning his absence. And when defense counsel could have objected and asked for more time and did nothing, we reviewed for fundamental error only. Apply the same rule here.
Okay, now I'm a little bit confused because I discussed the Jackson case in a lot of depth, and as to the third issue, the one about the waiver of counsel, and I'll be happy to address that in terms of that issue, but then I'm moving off of the one I started with. I'll come back to it.
It seems to me, though, that you kind of have, before we get to the difficulty in the relationship, the real question is, was he absent? From a Sixth Amendment standpoint, as to issue 1 and issue 3, the question is, what's the deprivation of counsel that Mr. Figueroa Sanabria ultimately suffered? And so Jackson, it seems to me, speaks to both of these questions. Let's assume that counsel was physically absent from the room, physically absent from the proceedings. Help me understand from a Sixth Amendment standpoint how we are compelled to find fundamental or even other error here.
Okay, well, again, I mean, on the waiver of counsel issue, he was absent, and I mean not physically absent because he was there, I guess, as standby, but he was doing nothing as he should have done nothing throughout the entire penalty phase up until the midst of jury deliberations. And all of these issues intersect. They all dovetail with each other, but he was absent as counsel throughout the entire penalty phase until halfway, part of the way through deliberations. On the first issue, it's not a question of whether he was absent. I mean, he was there. He was not, according to his own ongoing statements, he wasn't really doing much until toward the end. I mean, the first issue is not an absence case. It's the issue has to do with when the attorney-client relationship completely breaks down, that it is a abuse of discretion and a Sixth Amendment violation not to appoint substitute counsel when that occurs. And that's a rare occurrence, but it occurred in this case.
Your position is that, as to issue 1 now,
right,
the relationship was so deteriorated here that we should find that Mr. Figueroa Sanabria had no counsel and that he didn't choose that.
That he couldn't choose who his new counsel would be.
Or to have no counsel at all.
Well, he did. Well, all right. The way this went down, I'll try to do like a sequence of events here. Very early on, this spanned 3 judges. In front of Judge Lee, Mr. Hammond said in front of his client, "I have an ethical problem here." And he was talking about, I have this small private practice. This becomes a theme throughout the whole thing. I have this small private practice, and I have an important staff member who's out sick, and I'm in the office at night. I'm making copies. I'm filing. This just is, I got an ethical problem. And the judge says, well, more or less, we'll see how this turns out. And there was nothing wrong with that ruling at that point. This is, I talk in the brief about where was the tipping point where it became an abuse of discretion not to give him a new lawyer. Now, the case law, and very little of it is from Florida. Florida just basically says it's abuse of discretion standard. But I cited cases from, I believe, 9 or 10 states, 9 federal circuits that all have variations on the same 3-part or 4-part test. And the test in that situation is, number 1, timeliness of the request. Number 2, adequacy of the inquiries. Number 3 is the extent of the conflict, and number 4 is, well, was the defendant largely substantially responsible for the conflict? All 4 of those factors weigh heavily in Mr. Figueroa's favor as to why a new attorney should have been appointed. In terms of timeliness, and I cited the Young case out of Nevada for this. He very early on, from 5 years before the trial eventually took place, he was saying, my lawyer is too busy. He doesn't have time to work on my case. He's not working on my case. He doesn't tell me anything. I write to him. I have family members call him. He doesn't respond to my request for information.
Well, counsel, aren't those kind of complaints pretty common?
Very common.
And I understand you're saying that this was raised to a different level than the ordinary, but you also, I think, started out by acknowledging you can't point to any specific deficiency in the way counsel actually performed in preparing for the trial or at the trial. There's something that counsel should have done that counsel didn't do that's related to this point. Isn't that correct?
That would be an IAC claim. Right. I hope that post-conviction counsel doesn't have to do an IAC claim. This is a completely different issue.
You're trying to head that off on a different issue.
I mean, what could have been done differently, what he did that he shouldn't have done, what he didn't do that he should have done. I mean, I can look at the record and I can see.
But isn't that where we really, these kinds of issues typically get dealt with?
Typically, yes. But again, this is not a typical case.
And so we would be really making new law in Florida if we went your way on this issue.
You wouldn't be overruling any part.
I understand, but we'd be making new law.
Okay, the court in Guadardo and I want to say, trying to remember the names of these cases. It's 3 cited in my brief. I think there's a Walker and one other one. There are cases that say that it's an abuse of discretion standard whether substitute counsel should have been appointed. So it is an issue that has been recognized as something that can be raised. There is not any Florida case law that I found or that my opponent found that specifically rules on it one way or the other. But like I say, I have cases from 9 federal circuits and 9 or 10 states that do talk about it. The main ones that I rely on are Moore out of the 9th Circuit, Hendershot out of Montana, and Young out of Nevada, particularly those last 2, because they're actually pretty similar. But I'm sorry.
I know. I just moved the microphone.
The thing that takes this case, Justice Kennedy, you said, isn't this common? Yeah, it's extremely common. What's not common is for the attorney to basically not dispute the allegations and, in fact, most of the time agree with the allegations. I mean,
Well, that might not be real common, but it's not unheard of.
Well, I suspect you might find some cases where that don't make their way up here where judges have granted it. But in this particular situation, there would have been, in other words, I think a undercurrent that runs throughout this entire thing is something I used to hear when I was 8 years old. If we let you do it, everybody's going to want to do it.
We have ruled that we reserve all the ISC ineffective counsel issues during that stage of the proceedings once we get there.
Right.
And I believe I dissented to that, but we have ruled in that regard. So I'm just, I don't want to use up all your time, but there's one issue that I'm very interested in if you want to get there. I don't want to disturb your
Well, what I'll do then, because I do have a number of issues I want to argue. Okay. And the client is in, the court may not know this because of what occurred in the penalty phase. Mr. Figueroa is interested in all of the issues, but I gave him the choice of whether I would lead with the first phase issues because I thought that both were worth arguing, and that was his preference. So I will argue the same. But on the issue of substitution of counsel, I'll move on unless any justice has any specific questions they'd like to ask me. Okay, then moving on to the second issue, and this is a theme of this entire case, which is that there was controlling law that the judge didn't know. That's true on issue 2, the cell tower search warrant. It's true on issue 3, the waiver of mitigation, which resulted in an invalid waiver of counsel. And it's true on issue 5, which is that the judge could have appointed independent counsel to present the mitigation to the jury, or could have called the witnesses who were there and lined up and ready to go as court witnesses. But it's clear from his own statements, A, that he thought the jury should know the mitigation, but B, that he didn't know that the law allowed him to do that. Now I'll move to issue 2, because it came up in a really
Counsel, could you focus on the waiver of mitigation, or the misadvice regarding the impact of the waiver of mitigation on your client's access to counsel?
Yes.
Because as you described earlier, during the whole penalty phase until the deliberations, your client was without counsel because he had been presented with what is acknowledged to be a false dilemma that based on a misunderstanding of the law. Could you focus on that?
Yes, I will.
I think that might be a productive.
Well, I like I say, I do think it's problematical.
And that's the point I wanted to hear.
Okay. Well, like I say, without
if you can take a hint.
Right. Yeah, I'm taking a hint, but on the other hand, that will get me a new penalty. That will get Mr. Figueroa a new penalty phase, which would be great, but it's not everything that he would like to get. And I am in no way backing off of the issue on the cell tower, and I'll get back to that if I can. But, all right, so what happens, and I think reading between the lines, this plays in with his frustration with how the entire case was going with Mr. Hammond, because Mr. Figueroa had cooperated with, he liked Danny Hernandez, his penalty counsel. He cooperated with Dr. Eisenstein. He met with Dr. Eisenstein, I believe it was 15 times for a total of 30 hours, which is probably way more than he met with Hammond. And he cooperated with the PET scan and the MRI with Dr. Wu. Mr. Hernandez had mitigation witnesses lined up and ready to go. He had the two doctors. He had family member witnesses who would have testified about his abusive, nightmarish childhood in Puerto Rico and other aspects of his life. They were there and ready to go. And Monday morning rolls around right after the guilty verdict, and Mr. Hernandez, the penalty attorney, says, I've run into a problem here. He doesn't want the mitigation presented. I have our witnesses lined up and prepared to proceed, but obviously I was not seeking to do something against his wishes, but I suspected the court would require me to do so. Judge says, what's this all about? You don't want mitigation presented? And the judge tries to talk him out of it. Heart's in the right place. It's what he should have done. You know, I understand the jury makes the decision that they should make that decision with full knowledge of all the mitigating factors, full information. So if Mr. Hernandez, I'm getting back to your question, Justice Kennedy, so if Mr. Hernandez wants to call them, I'm going to let him call them so they can do what's necessary. Okay, Figueroa responds to this with a conditional, okay, I mean, I don't want to go through the mitigation. Then, if you are going to let him do it, then I would like to dismiss Mr. Hernandez, and I would represent myself, and I don't want no mitigation, Your Honor. Okay, judge asks Hernandez for his input. Hernandez specifies what the mitigation witnesses would talk about. Prosecutor says even though the client will not cooperate with the state's Dr. Lazaru, he's not trying to exclude any defense mitigation witnesses. And then Judge Syracuse says this to Figueroa. Now, you're saying that you're willing to represent yourself. If I'm going to order Mr. Hernandez to present things on your behalf, you'll represent yourself so that you won't have to present anything, because I may have to order Mr. Hernandez to present things on your behalf. That's what I say, Your Honor, yes. Okay. And there's a brief recess, and he's still trying to persuade Figueroa to present mitigation. It comes out a couple of times. It's real clear, by the way, and this is important, Figueroa is not a death volunteer. He is not waiving a jury. The judge asks him pointedly twice, do you want me to decide? Do you want to waive the jury? Figueroa says no. So the state's reliance on the Hamlin case is completely misplaced. Okay, so here we are again. This is the third time now. It's already been done twice. Okay, if you tell me you don't want any mitigation presented, I can't have Mr. Hernandez go forward representing you, not presenting any mitigation. He has mitigation ready to begin being presented, including the doctors, including your family members. So if he represents you, he's going to present mitigation on your behalf. On the other hand, if you wish to represent yourself, I have to have you talk to Dr. Porman to make sure you're competent. Okay? Subject to that competency determination. Now, this is the fourth time now. Do you wish to represent yourself, understanding if I allow Mr. Hernandez to continue to be your attorney, that I'm going to direct him to do his best to prevent you from getting the death penalty, which is going to require that he put on mitigation? Also, just to make sure we're 100% clear, I could order him not to put on your family members if you want to spare them, but he would still put on the doctors to testify on your behalf. Do you understand that? I do understand it. With that in mind, do you want to represent yourself, or do you want to let Mr. Hernandez present the mitigation against your witness? Binary choice, either or. Got to do, if you don't want mitigation, you've got to waive counsel. Figueroa, I don't want no mitigation. Okay, the court says, okay, so you want to represent yourself and not put on any mitigation. Yes, Your Honor. Okay. Let's see if there's any more.
You really, counsel, you're spending so much time on this, and the court has read this part of the record. You have a good legal argument. I think you should, kind of get to that. Not move on from the issue, but
right. I understand. I just want to make
it
very clear how.
Nothing ambiguous about it.
Nothing ambiguous about it, and that is important. And I relied very heavily on the very well-reasoned decision of the Louisiana Supreme Court in State versus David Brown, 7-1 decision, okay, which is almost identical to our case here, except that it was not as clearly 4 times repeated binary choice. Do you want to waive mitigation? Do you want him to put on mitigation against your wishes, or do you want to represent yourself? That happened in Brown as well, but not as overwhelmingly. Now, the state has this to say about Brown in their answer brief: nothing, bupkis. Okay, they don't argue it's wrongly decided. They don't argue that there are contrary cases in Florida or anywhere else. They just ignore it. Okay, but that case is a constitutional case on all 3.997s, as I said, that as a matter of constitutional law says this was not a valid waiver. This was an invalid waiver. This was a coerced waiver. This was a misadvised waiver. And that is an error of constitutional dimension. It's fundamental and it's structural. I'm going to get back to Justice Coriel's question here. I cited 7 or 8 cases, maybe close to a dozen in a brief, that says this is structural error. And I did about a week ago, I did a notice of supplemental authority with 5 more cases, including the U.S. Supreme Court decision in Breck v. Abrahamson that says this is structural error. The state comes back with their own notice of supplemental authority citing United States versus Roy, which is a case that I argued extensively in my reply brief, and a case called Middleton, which has nothing to do with the issue. Okay, now Roy is very similar to the Bertha Jackson case. They're both late from lunch cases. And in Roy, the attorney missed, I believe it was 7 minutes out of a 39-hour trial. He missed 18 questions to the 12th out of 13 witnesses, and those answers were repeated in even more detail when the attorney got back. Okay, so, and Roy talks about basically whether it was a substantial portion of the trial the client missed. Now, we're not talking about a late from lunch case. We're not talking about a United States versus chronic inadvertent or negligent absence. We're talking about not only an invalid waiver of counsel, but a misadvised and coerced waiver of counsel.
And so you kind of conflated or spoke of structural error and fundamental error without distinguishing between those.
Well,
could you clarify what your argument is on the standard of review here for this? If we assume that it was not a proper waiver, that it was coerced, that it was involuntary, et cetera, what's the test then for us?
I admit that I conflated the two because I think that the reasons for it being fundamental and the reasons for it being structural are similar. The Jackson case talks about both of those as well. In terms of structural, like I say, the overwhelming case law from everywhere, including the U.S. Supreme Court, says it's structural. Logically, it's structural. It affects the entire critical stage of a capital penalty.
Should we treat this as a preserved error, though? Because that seems like it makes a huge difference.
Well, it raises the question. I mean, who would preserve it?
Right. So can you elaborate?
Right. I mean, the client did what he could. The client, by the way, he was still pro se when this is going on. I mean, he's reacting to what the judge is saying. The judge is giving him misadvice under the law. The court has decided cases basically saying you can't hold pro se defendants to the same highest standard of knowing the law as you might with an attorney. But the thing, if the Judge Siracusa was not aware of Grimm, Boyd, Bell, and Hojan, how can you expect Reynaldo Figueroa to be aware of Grimm, Boyd, Bell, and Hojan? From his vantage point, the judge is telling him, I'm going to have him put on the mitigation whether you like it or not. He objects to that, and he objects the only way he knows how. He says, wow, then if you're going to do that, then I guess I have to represent myself.
But
as
counsel,
far as
wouldn't it, maybe I misunderstood the timeline. Was his counsel still representing him when this misadvice was happening?
Yes.
And did counsel object to the judge's misinformation or misadvice?
Well, as was the theme, first of all, I don't think counsel necessarily knew the law any better than the judge did. But in addition to that, he had no reason to object because the judge was doing what counsel wanted him to do. Counsel was basically saying, Judge, order me to put on the mitigation. That's what I want to do. And again, his heart was in the right place. That's what we all want to do. I mean, you do all this work to marshal the mitigation, and you genuinely believe that there are reasons why your client should be spared the death penalty, and then out of the blue, he says, I don't want any mitigation now, even though he's cooperated with it all up to now. I mean, Mr. Hernandez wanted the judge to do what he did, so he wasn't likely to object.
Do you concede that Mr. Figueroa Sanabria would have directed Mr. Hernandez not to present mitigation evidence even if he had not been discharged?
Could you repeat the question, please?
Yes. Do you concede that Mr. Figueroa Sanabria would have directed Mr. Hernandez not to present mitigation evidence even if he had not been discharged?
I believe he probably would have done that unless his concern was he wanted to get on with his appeal, as quickly as possible.
Right, so
so he ultimately did relent in the Spencer hearing, and he allowed Mr. Hernandez.
So if you concede that, where are we? If notwithstanding the misadvice and notwithstanding the way things worked out between the two of them, that was nonetheless going to be his instruction to counsel, where are we? How does this constitute?
Where we are is at reversal for a new penalty phase, because a waiver of mitigation, which I concede he most likely would have waived mitigation anyway, but a waiver of mitigation is not a waiver of the law. It's not a waiver of the right to counsel. It's not a waiver of a jury. It's just a waiver of mitigation. The trial court made it clear that the jury could consider mitigation anyway. Mitigation maybe that they heard in the first phase, and I'll get to one particularly apt aspect of that. But
doesn't this go to the heart, though, of the standard of review question? If it's structural and we treat it as preserved, then all of the speculation about what would have happened doesn't matter.
That's
correct. If it's fundamental error, then it does become appropriate to consider the fact that the defendant didn't want mitigation, that at the Spencer hearing he was represented and mitigation was presented, et cetera, et cetera. It becomes much more of a, is this some sort of fundamentally unfair proceeding or whatever. So it seems like it really does come down to whether we treat it in the preserved/structural box or whether we go through this more kind of holistic analysis.
Correct. And the Jackson case itself basically says, and again, I can't emphasize this too much, Jackson is a late for lunch case, not an invalid waiver case. But Jackson makes it clear that issues like this are ordinarily structural and they're ordinarily fundamental. It just wasn't in Jackson, because what happened in Jackson was it was a late for lunch case where they were doing victim impact. The judge eventually calls in the non-capital victim impact. The lawyer calls in. The judge kind of recaps for him what's been said so far. The lawyer then continues to participate during the victim impact and the entire rest of the sentencing proceeding, points out that the victim thought that the bottom of the guidelines was too lenient, but that a 30-year sentence was too harsh, and he was eventually, Bertha Jackson was eventually given 5 years.
You're
right.
2.5 minutes into your rebuttal.
Okay. I figured this would happen. I certainly will rely on my brief on the other incredibly egregious issue, which is structural and fundamental, which is the absolutely inexplicable bollocks non-verdict in this case, which basically said 3 times, the aggravators are sufficient, the aggravators are sufficient, the aggravators are sufficient, said not a word about mitigation, not a word about weighing. We know the jury was confused because they said so. We know that the judge's answer to the jury's confusion, if anything, only perpetuated it. I will sit down now.
You're talking about the verdict form?
I'll talk about the verdict form in the last minute.
Right. Thank you.
May it please the Court, Timothy Freeland on behalf of the state of Florida. This is a horrific case in terms of facts. The 2 victims hired the defendant as their handyman. They lived on a large houseboat. He had access to the boat, and the evidence established that in the middle of the night he entered the boat, used his own key to enter at a time when the victims were most likely asleep. He brought duct tape and a knife. He bound them up, and it appears from the evidence and what the medical examiner testified to that he tortured them until he got the combination to the safe, and then he killed them both. The evidence was that the female victim, Germana, had her throat cut by this defendant, not just with 1 slice or 2 slices, but it took 3 cuts to complete what the defendant wanted to do. The other victim, John, was stabbed 11 times. Not all of those 11 times were fatal. It appeared that at least one of those stab wounds was penetrated the lungs, and that it was possible that he either was stabbed twice in the same place or that the defendant plunged in the knife and twisted it before he removed it. It's absolutely a horrific case in terms of aggravators. I'll start with issue 1 and just say that I really think that the state of the law as it stands now is sufficient to protect the defendant in a circumstance where he disagrees with counsel. This seems to me to be just a situation where we have a disagreement over strategy. And defense counsel who is experienced knows what strategy is going to work and has a better idea of what strategy is going to work than an inexperienced defendant. Moving on to issue 3. It is very significant to me that my opponent recites this language to the court, which is what I was going to focus on. It appears on page 3062 of the transcript. It's the first day of penalty phase. Defense counsel, this is the first time that Mr. Hernandez is fully representing the defendant for the purposes of the penalty phase. And on the morning of penalty phase, court is convened, and defense counsel advises the court, I've spoken to my client, and he tells me now that he does not want mitigation presented. I've told him that we've investigated mitigation, we have all of our witnesses lined up. I've also told him that I don't want to do something that is against his wishes. However, I suspect that the court is going to require me to do so. I don't know how to characterize that statement. It certainly does not preserve the issue. And it seems that defense counsel was actually perhaps leading the court in a particular direction, because that's exactly the direction that the court went in. At no point did defense counsel, in fact, there were 3 experienced defense lawyers sitting at the table. At no point did any of those lawyers stand up and say, Your Honor, this is the improper procedure.
But counsel, I mean, I understand what you're saying, and it's, but you would have to confess that this is badly messed up.
Badly messed up.
I mean, during the time I've been here, I'm not sure I have seen anything quite as badly messed up as this. And I've seen some.
I can't disagree with the court, but I still think that an appropriate, timely objection would have eliminated everything that followed, because Defense counsel could have told the trial judge, Your Honor, my client is the captain of this ship. My client.
Let me ask you this. Say this played out the same way at the very beginning of the trial, because obviously we can have these disputes between counsel and the client over what ought to happen in the penalty phase, but it can also happen throughout the trial, in the guilt phase as well. But there are certain things that the defendant can decide. Okay, the defendant, and there's a list of them. This is within the scope of the defendant's right to decide.
You mean like mitigation?
Right. Well, that's what happened here. But I'm talking about even elsewhere in the trial, there are certain things that the defendant can decide. And so there's this kind of dispute over one of those things that's within the scope of the defendant, a right to decide, and the judge says, well, if counsel wants to do that, if you don't want him to do it, you're going to have to represent yourself. And so the defendant says, well, I guess if that's my only choice, I'll represent myself throughout the whole trial. Through the whole trial. Would that be okay because the lawyer didn't make an objection and the judge was so confused?
Your Honor, I'm absolutely convinced that if defense counsel had said, Your Honor, you got the wrong idea here.
Well, I'm saying, would that be okay? And would we just say, even though this person was wrongfully deprived of the assistance of counsel, would we say that because the lawyer did not make an objection, that it's all going to be okay, unpreserved, not fundamental?
In a circumstance where a timely contemporaneous objection would have told the court, Your Honor, you're doing the wrong thing, don't do that way.
So for the person to go through the whole trial without a lawyer?
I wouldn't like it, but I still think that it's subject to a contemporaneous objection.
That just seems pretty fundamental to me.
Can you talk to us, though, about the case law? So there is this oddity here about the quasi sort of invited error aspect of this, but it seems like in these cases, the reviewing courts kind of assume that when it gets to the point where the judge has a lot of discretion here, both in terms of the wording of things and in terms of the ultimate decision, but when the judge is going through the colloquy with the defendant about the waiver of counsel and all that, it's very much of a sort of it's about the relationship between the defendant and the judge, and it doesn't seem like it's almost so kind of assumed that the courts, from what I can gather, and it talks about it in this Hakeem decision from the 11th Circuit, they just kind of assume that the reviewing court then kind of looks at that de novo, and that it kind of just, because of the nature of the inquiry, it doesn't make any sense to start with the premise that the defendant doesn't understand the law and then expect the defendant to raise an objection. I also don't see the courts kind of thinking that it's the lawyer's job, who's at that point kind of sidelined, to be kind of interjecting. And so can you kind of point us to something that would, that cuts against that, where we wouldn't kind of look at the preservation issue through that lens here?
I'm not entirely sure what the court is asking me.
Well, give me some authority that says that when a court botches the colloquy, that you still look for, whether there's a preservation and who's supposed to do it and how, because it just doesn't seem like there's really precedent for us looking at it that way.
Well, I think that, we look at the Jackson case.
But the Jackson thing, where the person was represented and the lawyer was gone for a few minutes, I mean, that has nothing to do with this situation.
But the analysis, I think, still remains the same. Because, if we look at the entire penalty phase, and, if we look just in terms of transcript numbers, it's about 1,100 pages. The time period during which Mr. Figueroa was proceeding pro se was only around 100 pages. And I don't mean the numbers of the pages is what we look at. I'm just saying that it was a small portion. Now, what happened?
A small portion of what?
Of the entire penalty phase. So if we look at what happened during that time period, when Mr. Figueroa was proceeding pro se, he got what he wanted, which was no mitigation being presented to the jury. That was his goal, after all, and drove everything here, I think. But also, the state put on one witness. That was the medical examiner. And the purpose of putting that witness on was to support an additional aggravator, that aggravator being that the victims were particularly vulnerable. If the court is considering that some type of relief, I mean, I'm not stepping away from my argument that this requires preservation, but if the court is looking to fashion some type of remedy, I would suggest that the court could look at that aggravator. During the time period when the defendant was unrepresented, that aggravator, the evidence of that aggravator came in. All the remaining aggravators, and we've got CCP, we've got HAC, pecuniary gain, all of that evidence was presented during the guilt phase when he was represented.
Okay, but help me understand, during the penalty phase, for what portion of that was the defendant represented by counsel?
As soon as, during the time when the jury was considering its recommendation, hearing the testimony and when they were instructed by the court, during all of that period of time, the defendant is acting pro se.
Well, after it was over.
Not after it was
essentially.
Over. Well, Your Honor, there's still the Spencer hearing.
Well, I understand, but.
So the jury comes back and the jury has a question, and at that point, defense counsel says, defendant says, I need counsel. And counsel is appointed, and for the remainder of the penalty phase, defendant has counsel.
Didn't we just send back a case haven't we just recently dealt with the case with sending something back for a new penalty phase on the basis that the counsel was inappropriately taken away just during the Spencer part? I mean, it seems like this is even. I mean, if that's the right remedy there, I don't know why it wouldn't be here.
Well, we have to look at what the goal of the defendant was. I realize that he was unrepresented for a portion of it. I realize that possibly the trial judge felt, based upon what defense counsel told the trial judge, that the only options that the court had would be to allow the mitigation or, fire the defense lawyer. I still don't think that. I still think that we have to look at what happened, and if there is if the court needs a remedy, I think that's the appropriate remedy. The court has in the past found that when a particular aggravator is unsupported by the law or improper for whatever reason, we strike that aggravator and then look whether the remaining aggravators are sufficient. And here, the jury made unanimous findings as to all the remaining aggravators. If the court has any other questions, I'm open. And as to the remaining issues,
Can you address the verdict form?
Yes, certainly. The verdict form itself, if the court looks at the verdict form, and it's contained in the record on page 2429, the jury was asked to find whether the aggravating factors were sufficient to support death. They were asked in slightly different language, that same thing 3 times. This is not, it's not a standard verdict form.
But we do have a standard form.
We do, correct.
Why would the state present the court with this?
I really don't have, it's not in the record, so I can't speculate as to why this particular verdict form was fashioned in the way that it was. If I were to speculate, I would say it could have been driven by the fact that the defense had not put on any mitigation.
Well, having been a trial judge who presided over cases like this, I can speculate that my first question would have been, don't we have a standard for this?
That's a good question, Judge. But remember, when the jury came back and said, we don't understand this verdict form, defense counsel was representing the defendant and made no statement about, well, we don't like, this, we should have this or that changed. The rule is that we presume that the jury will follow its instructions. And if we go and look at what the court did in instructing the jury in terms of you have to consider whatever mitigators there are and weigh them against the aggravators and so on, we presume that the jury followed those instructions. And even though this verdict form is abbreviated, it still contains sufficient findings to support a death penalty. Thank you.
I don't even hardly know where to start. I mean, if the verdict form was sufficient, contained findings sufficient to support the death penalty, I mean, if it's sufficient to say aggravators are sufficient, aggravators are sufficient, aggravators are sufficient death, then it would be sufficient. This is a non-verdict, and you cannot, constitutionally, Mr. Figueroa cannot be executed on his verdict form.
So the standard verdict form would have had the mitigators.
The standard verdict form would have said one or more jurors finds one or more mitigating circumstances. Then it would have said once, not 3 times, the aggravators are sufficient. And then it would have said there's 2 places. I was thinking at one point that it could have almost been a typo to cause this to happen, but I don't think so, because the standard form has the aggravators outweigh the mitigators in both Part D and Part E. And that was completely absent. So I don't know what accounts for it.
Isn't that, I mean, the form, though, that's all sort of extra textual, extra legal, in the sense that it seems like really the form should only ask the jury 2 things. One, do you find, an aggravator proven beyond a reasonable doubt, and then however many are at issue, and then do you recommend life or death? The things that happen in between that, they're not anything that, that are the weighing, the sufficiency, the mitigation, whatever. They're not anything that the jury has to find factually, unanimously, et cetera. It's what they need to agree on is the aggravators, and our case law says that sufficiency means that you found an aggravator, which makes you eligible, and then the ultimate unanimity on the recommendation. So why does it matter sort of what's on the form?
The thing is that the Furst v. State said you needed unanimous findings as to all 4 things. The statute does not directly say that, but the statute was passed in an attempt to comply with Furst. Then this court adopted standard jury instructions and a standard verdict form, both of which say that. The state in 2021 appeals, at least 3 of them that I found, after Poole, after McKinney, term those as non-factual selection findings, statutorily mandated selection findings. Now, if you want to do textualism to the point of saying that the only thing you have to do is ask 2 questions, not 4. The second question, though, is based on a weighing of the following factors. The aggravators are sufficient to warrant a death sentence, and the aggravators outweigh the mitigators. Now, even if you could vary the verdict form, and nobody asked to do that, the judge, if he wants to vary the standard verdict form, has to make a specific finding, either orally or written, as to why he's varying from the standard jury instructions. That didn't happen here. But, okay, let's say that he had done that. Then the form, the revised form, should have still said, based on consideration of A, the aggravators are sufficient, and B, the aggravators outweigh whether the aggravators outweigh the mitigators. Based on those considerations, then do you unanimously find that the defendant should have been sentenced to death?
Okay, I'll give you 30 seconds to close up.
Okay, thank you.
No, you have 30 seconds. If
I got 30 seconds. Yeah. I don't know where to start, but
actually, it's time to finish.
Yeah, well, where to finish? The Jackson case. Undoubtedly, the right to counsel is a fundamental right. Florida courts, including this court, have found deprivations of counsel to be fundamental error. Cite 4 or 5 cases. Okay, they talk about the Satterwhite. If the state could, I don't hear them to have done this, they could have said that, well, it wasn't a complete deprivation of counsel because he came in there during deliberations and he had one job to do at that point and he didn't do it. Okay, but Jackson cites the Satterwhite case, and I've got many cases cited in my brief that talk about whether counsel was absent for a substantial portion of a discrete critical stage of the proceedings. The critical stage is the jury penalty phase. The judge gave great weight to the jury's penalty verdict. You can't fluff that off by saying, hey, there was a Spencer hearing. I've used all my time. Thank you.
Thank you very much. We're adjourned.
All rise.